Welcome to today's video. I'm Richard Chapo. I'm an internet lawyer in San Diego, California. And today we're talking about the CCPA and private right of action. So the CCPA is the California Consumer Privacy Act, and it is a new privacy law in California. It goes into effect January 1st, 2020. A private right of action is a fancy way of saying a lawsuit brought by an individual or a group of individuals in civil court, and the remedy that they are typically seeking is monetary damage. So they want money. When you see somebody sue somebody and the result is an award of X amount of money, that is a private right of action. That is a civil lawsuit. So in this case, the CCPA is unique in that it divides up the potential legal actions for violations of the CCPA into two groups. One is an enforcement action brought by the California Attorney General, and the other is the private right of action brought by an individual. Now, there was a large amount of money and a large amount of effort put into the California legislative lobbying process to try to either expand or limit the private right of action in relation to the CCPA. It looks like everything is resolved now, and it looks like the final disposition is that private right of action will only apply in situations where there has been a data breach that is alleged to have violated some aspect of the CCPA. So there are a whole bunch of different sections of the CCPA, but only the sections on data breaches, or only the claims brought under the data breach sections, will give rise to private lawsuits. All other violations of the CCPA will be the sole jurisdiction, if you will, of the Attorney General of California. So, for instance, if a customer or somebody comes to your website and they request a right of deletion, and you refuse to delete their content, which would be a violation of the CCPA, only the California Attorney General could come after you for that. Not that that's a great thing, but generally speaking, California Attorney General actions are going to be more palatable than an individual lawsuit. Now, with the individual private right of action, let's cut through the chase and tell you what the real game is here. The real game is individuals aren't going to sue for data breaches. What's going to happen is they're going to team together in what's called a class action lawsuit, and that is essentially an action that is brought by a group of people who have all suffered the same harm, alleged harm, in the same kind of a situation with the company. So if we think back to, for instance, Equifax, the credit agency, they were hacked. Well, everybody who had a credit report with Equifax that had their information exposed, they all suffered the same harm. And so if there was an error in the Equifax system that would have violated the CCPA, and the CCPA was in effect, then we could all bring a class action lawsuit against Equifax for the data breach. And I say we all because, unfortunately, I was included in that data breach. But it is what it is. Now, for any other violations, again, only the California AG. So that's important to know. Now, there is a twist on the data breach class action lawsuit possibility that is going to be litigated, and there'll be a good amount of money spent on this. And it has to do with a conflict between federal and state law. So the CCPA says you can bring a private right of action for data breaches. And that sounds great and all. And what we really know is they're really talking about you can bring a class action lawsuit. However, the United States Supreme Court issued a decision in a case called AT&T Mobility versus Concepcion in 2011. And that decision said simply that businesses could force consumers to waive the right to a class action lawsuit and waive the right to a criminal or to a civil trial by including a mandatory arbitration and class action waiver provision in the terms and conditions associated with the transaction in question. And that includes website terms and conditions or app terms and conditions. And so this is why you've seen a lot of websites and apps add this kind of language. They are trying to limit the legal rights of consumers. And so what would be the advantage of sending it to arbitration and waiving the class action lawsuit? Well, the advantage is in arbitration. Arbitrations tend to be heard by retired judges or attorneys familiar with the area of law. And so they tend to be more favorable to businesses. And even if they do render an award, it tends to be much lower than a jury would issue. There's not a heightening of emotions, if you will, there. And as in relation to the class action, the important thing about waiving the class action right is if people can't participate in a class action, well, they're going to have to go get their own attorney. They're going to have to, pay that attorney some money to bring the lawsuit. And typically the damages in a data breach situation are not going to be high enough that they're going to be able to either attract an attorney or attract an attorney of particular quality. And quite frankly, most individuals won't even file the lawsuit. They'll just go, that's life, and off you go. And so it tends out to be a much cheaper resolution of the issue for companies. So the question is, will AT&T Mobility Conception apply in these situations and essentially defeat that class action lawsuit? And there's another twist. And the other twist is the CCPA also contains language stating that any effort by a company to contractually limit the rights of an individual, the rights of a California consumer under the CCPA are void as a matter of public policy. Well, when you're including that mandatory arbitration and class action waiver provision in the terms and conditions of your website or app, you are trying to limit the consumer's rights. So we have a conflict between the CCPA and the Supreme Court decision, and we have the proverbial square and the proverbial circular hole, and we're going to see that slam together in quite a few litigation cases, I imagine. And there's going to be a great debate as to how that should play out. And we'll just have to wait and see how it goes. But nonetheless, that is going to be a twist on the private right of action. And if the courts rule ultimately that AT&T Mobility versus Concepcion is binding law on the CCPA, well, then we may end up with a situation where there's, for all practical reasons, almost no private right of action, even for data breaches, because again, most individuals are not going to bring an individual lawsuit for a data breach. So it'll be interesting to see how it plays out. But anyways, so that's it for the CCPA and private right of action. As things stand now, a private right of action can only be brought in relation to data breaches. And even then, that prospect's a little iffy. So if you have questions about the CCPA or need assistance, feel free to contact me at SoCalInternetLawyer.com. You can also post below in the comments section, although please don't post anything that's confidential or sensitive, because of course there's no attorney-client privilege there. Everybody can see that information. If you're interested in learning more about the CCPA, please consider subscribing to this channel, as we'll be posting a whole load of videos on the law. And again, it goes into effect January 1st, 2020, so you might want to get started on compliance. Thank you for watching. Have yourself a good one.